than the onshoring transaction. So clearly it could have a very negative effect if it's not carefully managed. So I think an important question to look at the outset of any double Irish onshoring project is whether there's been a change of ownership of the group since 1 January 2015. And the rules that outline how a change of ownership is determined they're somewhat complex, but broadly they look at whether there's been a 50% plus of change in the ultimate ownership of the equity of the group. And you test that by aggregating all 5% plus changes in ownership in any rolling 3-year period since then. If there hasn't been a change of ownership of the group post 1 January 2015, then the anti-avoidance rules are not applicable and not in point, so it's more straightforward. Where there has been a change of ownership, so for example, if there's been a takeover of the group or an IPO post 1 January 2015, then it is important that the IP onshoring is implemented in such a manner that it doesn't amount to what is a major change in the business of that non-resident company. And that term, so major change in the nature of the business, is specifically defined in the legislation, but broadly it means a major change in the business of the company which arises from an acquisition of property. So it is possible for these structures to be unwound without triggering that kind of a major change, provided the steps in the onshoring are carefully planned. And we have worked with clients to achieve that successfully in the past, but it is something that still needs to be kept on the radar.
All right, yeah, thank you. So you signalized that there's some potential risks, but you also have mentioned in the video about the potential risk in the valuation and anti-abuse provisions. Can you just talk a bit more about them in this session as well?
Sure. So yes, the IP valuation, clearly in a transaction of this nature, it's a key element from an Irish perspective in any onshoring transaction, because it essentially supports the quantum of tax depreciation allowances that can be claimed by the Irish company that acquires the IP into the future. And we have seen Irish Revenue audit these transactions, so it is best for taxpayers to expect generally that the valuation will be reviewed. So, you know, taxpayers should have all of their documents ready, keep a full audit trail, make sure that they have backup files ready and accessible to support any positions taken in terms of the valuation. Specifically under Irish legislation, Irish Revenue has the power to appoint an expert in order to review the valuation, and we've seen that they do this. They're required to notify the taxpayer in advance and indicate the information that will be disclosed to the expert. They also have to notify the taxpayer of who the expert is that they've identified, and then the taxpayer has the ability to challenge that or to request that, for example, certain information be held back to the extent it could be prejudicial to the taxpayer's business. So that taxpayers should in all cases consider their rights initially under these provisions at the outset to the extent that they're notified of a review. The expert then will perform an independent review of the valuation to test the reasonableness of the positions taken, and you know the points focused on will vary depending on, I guess, the valuation methodology used and the specifics of the case.
All right, yeah, thank you, Susanne. Welcome. I think just taking from what Amelia was talking and the whole structure on Ireland for onshoring. Moving then to Switzerland, your counter of expertise, did you also saw an increasing trend like the one in Ireland for onshoring IP? The measures similar or they're somewhat different?
Thank you, and sorry for being a bit late. I had 5:15 in my calendar. Yes, we saw the same trend, not so much from a CFC perspective, because Switzerland has no CFC rules. So usually offshore companies holding IP were totally fine from a Swiss perspective. But there was an increased on offshore structures starting in 2014 when Switzerland or the tax administration noticed that we had several converter structures, as they were called. So offshore financing subsidiaries that received interest income and distributed dividends. And the same certainly applied also for IP. And in particular, with the BEPS project and the increasing transparency and the public focus on the low tax rates of certain Swiss groups, many of these started to onshore IP. Usually it was the rest of the world IP that was held in Bermuda or no tax jurisdictions. So usually no exit tax when you move the IP from these zero tax jurisdictions to Switzerland, and the possibility to acquire the IP at a fair market value and realize a depreciation basis in order to reduce the future corporate income tax. We also saw quite some onshoring of IP companies directly, so not the move of the IP, but rather the entity itself, so Bermuda relocating to Switzerland. Here, the challenge was, in order to have a step up on the IP, we really needed an accounting step up, because Switzerland tax law follows accounting. So if the IP was in the Bermuda entity at acquisition costs and migrated to Switzerland, there was no depreciation basis. So you first had to sell the IP to another company and then migrate to Switzerland. This has changed as of 2020. Now migration of companies can be done with a step up for tax purposes, even if there is no accounting step up. So that's easier. And that is also what a lot of groups consider, that they now want to move to Switzerland with IP or goodwill and make use of this tax step up and depreciate it in Switzerland. And that's also where the IP view that Amelia mentioned comes in. The tax authorities now scrutinize whether the IP that is migrated was actually outside of Switzerland, or in view of the DEMPE functions and the OECD 2017 guidelines, it was maybe only the economic owner, the legal ownership abroad, but the economic ownership and the key functions were already onshore, which means that you can't migrate the IP with a high value, but you would rather just migrate the legal ownership, whereas the economic ownership was already in Switzerland. And these are some discussions that we have now. Interestingly, that these DEMPE functions that I think no one knew before 2017 are often used as an argument by the Swiss tax authorities, as if these were a tax methodology since ages. So they now come and argue that in 2010 there was the DEMPE functions were not there, and that's why there was no effective transfer of the IP. Here we don't have a real solution. It's really a case by case that you need to discuss with the tax authorities where you land.
All right, thank you. Yeah, you're mentioning about the scrutiny. So besides that, what are the main risks that you foresee, like on the onshoring of IP to Switzerland?
Yeah, I think it's the main question is really the allocation of the IP, the intangible. Is it because in the past that was also the structures which were used in Switzerland, that you transferred the IP just by the transfer of the legal ownership and bearing the costs for the IP, but the R&D functions were certainly to a substantial extent outside. And this is, as we all know, not sufficient anymore, that you just are the legal owner and bear the costs for the IP. And these are discussions that are now brought forward by the tax authorities, that even if you onshore the IP, that's okay, but you would also lose your IP over the time or quite quickly if you do not perform the DEMPE functions in Switzerland. So the allocation of IP as in the good old days where it was a movable asset, where we said, well, financing functions, IP functions can be allocated wherever you want. You just need to legally transfer them and have the charges in this country. That's not possible anymore. And the main challenge in my point of view is really this transition from the old world to the new world. Because based on the old world, the pure legal owner has still the entitlement to the licenses, to the royalties, to the profit. But from a new transfer pricing perspective, he's certainly not entitled to it from a tax perspective. And that's just a clash from a legal to a tax perspective, which is challenging in order to justify the value. And the last point that we see as scrutiny for the IP is certainly the valuation in these times, where you have a COVID situation where maybe the IP that was onshored last year has lost a significant amount of value, where you can come into discussions with the tax authorities, was the value already too high, or where the taxpayer, if they transferred the IP, now wants to argue that the value was lower.
Just to mention, I think the DEMPE point is an interesting one from our perspective as well, in that, you know, these onshoring projects, we see the Irish transferee company, you know, looking at their governance structures post IP onshoring in the context of DEMPE. We're probably a little bit behind Switzerland in that we only adopted 2017 OECD transfer pricing guidelines into Irish domestic law in our Finance Act last year, so they took effect in Ireland for accounting periods of companies commencing after 1 January 2020. We do see, I guess, varying approaches to DEMPE. So for companies that have a very global operation that don't have maybe all of their control and DEMPE functions in one jurisdiction, we have seen them taking steps in the context of the Irish IP owner entity to enhance the composition, for example, of the Irish Board of Directors, or establish IP committees that would have strategic control and management of IP development, etc. And, you know, documenting decisions carefully, that sort of thing. But I think it is a developing area in Ireland also that we will see more of in the future, particularly depending on what jurisdictions the group actually has DEMPE functions in, and whether they apply 2017 guidelines or not.
Right, yeah, thank you for that. Maybe just then a question to Maria. Maria, based on what Susanne and Amelia were talking about, I would just like to understand, do you see a link between onshoring and value chain analysis, for example?
Yeah, definitely. Well, first of all, when you perform onshoring, as Susanne mentioned, you need to think of the DEMPE function. So you need to see how this fits within your total value chain functionally, because maybe where you onshore, you don't have DEMPE functions, or maybe DEMPE functions are rather scattered across several locations within your value chain. So you need to make sure that, this matches. And also this fits within your value chain, and maybe you need to create the whole new block and then allocate a certain value to it. And second, that connects to what I was discussing in the introduction session, where you need to look from the three perspectives. So from perspective of the value chain, so holistic view, transactionally, because if you onshore IP, you probably aim to charge royalties. And the third one is the valuation itself, and you need to see again that you did not put a too high label, too high amount for your intangibles, that it actually eats up the whole profit in the value chain, or that it's significantly not matches, because then you might have an issue that you moved an IP and suddenly created, not in real terms money, but if you will be allocated, you created kind of loss in your value chain, because your IP is, the value is too high. So you need to make sure this all aligns functionally, so qualitatively with the value chain and quantitative.
All right. Does any of of you, maybe Amelia or Susanne, you want to comment on Maria's interaction?
Yeah, I think one point that we discussed also in our preparation session was the possibility to overcome this valuation uncertainties with earn-out milestone approaches. I know that also in Switzerland, the tax authorities are sometimes a bit reluctant, but like in normal third-party transactions where you need to bridge the gap between the expectations of a high or a low value, I think that could be a possibility. Just also to avoid that either you pay too much or you pay too little, that you have a kind of a true up earn-out milestone approach that you can use. I know that the German colleagues, they know it from their relocation of functions, this the methodology, but I think it's sometimes can also be useful for both the taxpayers and the tax administration.
Yeah, I definitely agree with that. But have you seen it actually applied in practice, or as you said, the tax authorities are now being reluctant? Because I haven't seen it, honestly.
Well, we see it for really if you have intercompany transfers of typical of pharmaceuticals, for example, where it's clear that also from a third party view you have the different phases and different purchase prices per phase. That's also then usual for intercompany transfers that you apply these. And I think that's the only, in my experience, the only case where the tax authorities are also willing to accept it. In other IP cases like transfer of brands or easy IP, I have not seen it.
Yeah, well, this is true because indeed now that you reminded me of the pharmaceutical, well, we were not onshoring it per se, but yeah, I've seen that the tax authorities do look indeed at the phases of the development and milestones, and they see it as acceptable methodology because it's just an industry practice, really. But other than that, yeah, I think that would be more difficult to apply, unfortunately. Amelia, do you want to add anything?
No, I mean, I guess I agree with, again, similar perspective that we have not, outside of those kind of specific transactions that described, we haven't seen that approach. But I agree that it may be something that makes sense in the future.